Good morning, everyone, and thank you for joining us for the first part of our Planning for 2021 series under our new branded academic program called SCION. SCION, we launched a couple weeks ago and have been working on it the latter half of this year, but it stands for Sonoma County Industry Opportunity Network, and we are utilizing it as a way to brand and promote our current and existing seminars, but also as a way to develop a more in-depth content, expert panels, and then eventually add a resource on our website where we can library these kinds of presentations for our members to have current data and updated data. And we look forward to presenting a lot more in 2021 to you. But without further ado, I'd like to turn it over to Leah Cameron, and she is with CDF Labor Law, and she's done a couple in-person seminars, I think since 2018 with us, updating our membership on the current labor laws in the state of California. And we look forward to her giving us a presentation today. Just as a little bit of housekeeping, please keep your questions into the Q&A. We'll do our best to answer them throughout the presentation, but we will do a robust Q&A at the end. Also, if you have any general discussion points, put them in the chat feature. Thank you so much, and I'll turn it over to Leah.
Thank you, Jesslyn. I am happy to be here today with you guys. I'm sorry we're not in person because it's always fun to come down to the vintners offices and see you guys face to face and keep up. But I am very happy to be here today. I'm glad that Jesslyn invited me. I'm going to try to share my screen here with you guys so you can see my PowerPoint presentation. So we are here today to discuss California labor and employment law developments. This is a year-end update, so we're going to cover a lot of the primary stuff that has happened over the course of this year and the types of laws that you can expect to see going into effect early next year. Again, my name is Leah Cameron, and I am a partner at CDF Labor Law. We are a law firm specializing in representing employers throughout the state of California. I am broadcasting to you today from my home in Petaluma, so I am physically located in Sonoma County, but I work out of and I work with our team in the San Francisco office. So as I said, we have 5 different offices throughout the state, and so we represent and specialize in California employment law matters for our clients. One note for you guys is that we are going to talk a lot about COVID-19 related new laws and litigation today. However, we're going to be doing a special symposium in December that's a week-long symposium covering COVID-19 related issues for employers. Every day of that business week, we will have webinars from 9 to 10 a.m. If you register, you can also watch free of charge the replays on those if you're not available at the time. And you can see here on this slide the different topics that we are going to be covering during that symposium. So today, like I said, we're going to be covering new California laws. And most of the laws that I'm going to be covering with you today go into effect on January 1st of 2021, but there are some that have already gone into effect, and I will try to note those for you as we go through as well. So what are we going to talk about today? We're going to talk about new sick pay regulations, Cal OSHA health and safety issues that you need to be aware of, workers' comp rules that have changed and expanded this year as a result of COVID-19 and going forward, pandemic-related litigation concerns. Now, this doesn't have to do with new regulations that have gone into effect specifically, but has to do with the types of lawsuits that we're now seeing as a result of the pandemic-related changes in our work environments and our workforces. We have some more changes to independent contractor laws, which I know I've covered these in prior presentations for you guys, some of the changes that we've had in independent contractor status classification, but we have even more changes that have gone into effect that I'm going to cover. We also have CFRA expansion, so that's the California Family Rights Act. That's that 12 weeks of leave that employers provide to their employees. That law has expanded. We have pay reporting and board membership issues and a few other miscellaneous pieces of legislation to cover. So at the end of each of these sections, I'm going to try to give you guys a chance, hopefully I will remember, to raise your questions regarding the segment that I've just covered. So let's start with the sick pay issues. Okay, we have supplemental COVID sick leave. Assembly Bill 1867. So you guys already know in California, we have certain mandated sick leave that as employers we have to provide. But then we had, okay, a few months ago, we all had to deal with the FCRA, Families First Coronavirus Response Act, which required private sector employers with less than 500 employees to start providing 10 days of paid sick leave to their employees for coronavirus related absences and up to 12 weeks of FMLA leave to their employees who could not work due to coronavirus related closure of schools or daycares. So that was the federal rule that went into effect when the pandemic first arose, and that impacted employers with less than 500 employees. But now we have this supplemental sick leave bill that came through the California state legislature, which is trying to fill the gaps in that FFCRA rule. So this new this new state regulation requires employers with more than 500 employees. So that's probably not most of you here today, but maybe some of you. So if you have more than 500 employees, now you also have to be providing up to 80 hours of COVID-related supplemental paid sick leave to your full-time employees who leave home to come into the workplace. There's specific reasons for why this leave can be used. You may remember under the FFCRA, there's like 6 different reasons that you can use that COVID sick leave. And the permitted uses under this new bill are similar, but it's a shorter list. So if the employee is subject to a quarantine or isolation order, if they're advised by a healthcare provider to self-quarantine, or if they are prohibited from working because the employee has a COVID-19 health concern personally, those are all reasons that they can use this new supplemental COVID sick leave. A couple of additional heads up here. You need to have, there's a posting requirement. So this policy, this law has to be posted, and the hours of COVID sick leave that are available to the employees needs to be included on the wage statements. And there are some offsets that are permitted for other types of leave that the employer may already be providing. So your regular paid sick leave is not going to be counted toward these 80 hours, but if you have already provided some type of COVID sick leave to your employees, then that could potentially be offset against your obligation under this rule. Okay, so I'm gonna just move on from there and note that there's a couple other things that this bill does, which is it codifies the food sector worker supplemental COVID sick leave rule for large employers. And also food sector workers who are working in a food facility, this bill now says that they have to be permitted to wash their hands every 30 minutes or additionally as needed. Now, hopefully you guys are all doing that. And technically, I went back and looked at the regulations, and there is a very narrow exemption for certain limited wine tasting environments. However, I would definitely advise that the best practice would be to still comply and provide your employees with as much hand washing opportunity as they want or need. And we will talk a little bit about why that's a recommended best practice as we move forward. This bill also creates a small employer family leave mediation pilot program. And when I was setting up this presentation, I was trying to figure out, should I put this slide first or talk about the family leave expansion? And because the two issues are related. So as you will see later on in this presentation, the family leave that you are required to provide as a small employer, that is increasing. You now as a small employer have to provide 12 weeks of family leave to your employees. And one of the things that the legislature tried to do to address this is acknowledge that they needed to create some additional tools for small employers facing this new rule. So they created the Small Employer Family Leave Mediation Pilot Program. And this legislation has already gone into effect. And what this pilot program does is it creates an opportunity for small employers. So if you have 5 to 19 employees and an employee is bringing a claim against you for a CFRA related alleged violation, so a failure to provide that family leave, before they bring suit against you, within 30 days of receiving notice that they have this claim, you can request to participate in the Department of Fair Employment and Housing's Small Employer Family Leave Mediation Pilot Program. And then they have to go through that mediation program to try to resolve the dispute with you before they could bring a lawsuit on that claim. This slide here says that this new law sunsets at the end of this year, but that's related to the COVID sick leave issues, not the mediation pilot program. And again, that COVID sick leave rule for large employers, it does sunset at the end of this year, or it can be extended. It will be extended if the FFCRA is also extended, which I don't know yet if it's going to be, but I imagine that there's a high probability that it will. We also have local COVID-19 paid sick leaves, and I will say here that I probably should have mentioned this before, Santa Rosa and Sonoma County have local sick leave ordinances right now pertaining to COVID. So those ordinances really already were requiring employers with 500 or more employees to provide this 80 hours of COVID sick leave. So you just need to be careful to make sure that your policy complies with, if you're operating in Santa Rosa and Sonoma County, that you're complying with that rule if you're a large employer, as well as the 2 state rule. And then for smaller employers under 500 employees, you're just complying with the FFCRA. One last note on sick leave, moving away specifically from the COVID-19 related issues, we do have a change to the kin care provisions of California's general sick leave statute, which is Labor Code Section 233. That statute currently says that employees have to be permitted to use half of their sick leave for kin care, so to care for their family, not just themselves when they're sick. Well, this new law says that it is up to the employee's sole discretion to designate that sick leave as sick leave for their kin versus themselves. So you can't question their designation if they say, well, I took this time to care for my kid, or I took this time for my own illness. They have the sole discretion to designate it for one or the other. Before I move on to Cal OSHA, are there any questions about the sick leave issues that I've raised? Let's see. Seeing none, I will move on to Cal OSHA health and safety issues. Okay, let's see here. Okay, so now Assembly Bill 685 is requiring employers who receive notice of potential exposure of their workforce to COVID-19 to provide specific disclosures to their employees within 1 business day. So that's a really tight turnaround. And an exposure is considered any situation where an employee has contracted COVID or was exposed to it in the workplace. That's going to trigger your obligations here. And what you have to do within 1 business day is provide written notice to all of your employees, all of the employers of subcontracted employees working at your work site, or if your employees have an exclusive representative, you need to notify that representative within 1 business day of all of the information regarding COVID-19 related benefits that may be available to them, including workers' comp, leave, sick leave, state mandated leave, supplemental leave, anti-retaliation and anti-discrimination protections. You have to notify your employees within 1 business day of all of that. You also need to notify them of the disinfection and safety plan that you're going to implement. Then, in addition, within 48 hours, you need to notify your local public health department that if you've become aware of an outbreak occurring in the workplace. So an outbreak is defined for this specific purpose. Because you guys are not healthcare facilities, it's going to be defined as at least 3 COVID-19 cases among your workers at the same work site within a 14-day period. So once you have qualify for an outbreak, you need to also, within 48 hours of learning that, notify the local public health authority. In addition, Cal OSHA now can shut down your work site without providing any notice if the hazard that they've identified is COVID-19 related. So this law gives them the ability to do that. One more Cal OSHA update that we have. This is actually a rule that requires Cal OSHA to disseminate information and create some best practices information on their website related to COVID-19, including information on awareness and prevention, and it has to be easily understood by agricultural employees from a variety of ethnic and cultural backgrounds. If you think that information might be helpful to your workforce, you can access it at the link that I've provided below, and they have some handouts and training materials that are industry specific, and they have the information in different languages as well. Before I move on to workers' comp, I'm not seeing any questions. So I'm going to keep going. All right, in the workers' comp arena, I'm guessing that you guys, most of you were aware that earlier during the pandemic, there was a workers' comp presumption that the governor signed into effect via executive order back in March, which created a rebuttable presumption that if your employee contracted COVID-19 in the workplace let me restate that. If they contracted COVID-19 within 14 days of being in the workplace, there was a rebuttable presumption that they contracted COVID-19 at work, and that gave them a workers' comp claim for their COVID-19 related lawsuits. So that went into effect in March, and that executive order by the governor remained effective for COVID-19 incidents through July 5th. Now, after July 5th, we have a legislation that supersedes that executive order, which creates a similar rebuttable presumption that if an employee contracts COVID-19 in the workplace, there's a presumption, if they contract COVID-19, there's a rebuttable presumption that they contracted it in the workplace if they test positive during a, quote, outbreak. So there's still a rebuttable presumption that the employee contracted COVID-19 during the in the workplace, but it's slightly less onerous on the employee as the earlier presumption. So this one, the presumption only applies if the employee contracts COVID-19 during an outbreak. Outbreak in this context is going to be defined a little differently. If you have 100 or fewer employees, the outbreak it's an outbreak if you have 4 employees testing positive within 14 days. And if you have more than 100 employees, it's going to be if you have 4% of your workforce testing positive in that same time period. Then you've got an outbreak, and then anybody who contracts COVID-19 is going to be presumed to have contracted it at work, which is going to give them a valid workers' comp claim. Now, you can rebut this presumption. You have 45 days. You used to only have 30 days, but now under this new law, you have 45 days to try to rebut this presumption. And what kind of evidence is going to help you rebut this presumption is going to be your efforts to reduce transmission in the workplace. So that goes back to that hand washing issue, and also all the other best practices that are out there right now that Sonoma County Vintners has endorsed, and certainly following all of the health orders that are in place. If you can also present evidence of the employee's other risk factors or non-industrial risk factors. So let's say you are Facebook friends with this employee and you see that they've been getting together, big parties, not socially distancing. That could be evidence to help you rebut the presumption that that employee contracted COVID-19 at work. However, it's not clear how the efforts to reduce transmission are going to really impact the presumption analysis, given that now there's already an outbreak in place if this presumption applies. So we'll see how those mitigating factors are actually taken into account by the Workers' Comp Appeals Board. Okay, so in addition, there is now a reporting requirement to your workers' comp carrier, and there's fines for non-compliance. So you have to report, going back to July 6th of this year, you have to report any COVID cases that you've had to your workers' comp carrier. You were supposed to do that already. The deadline is passed, so if you haven't done it, go ahead and do it, I think. And then going forward, you have 3 days. Within 3 days of learning that an employee has tested positive, you need to notify your carrier, and you have to give them the information provided below. Okay, so I'll take any questions on that. All right, seeing none, I will keep moving on. Let's discuss pandemic-related litigation concerns. Okay, we've seen at least 150 employment-related lawsuits in California related to COVID-19 just in the last few months, including things like retaliation, wrongful termination, discrimination related to positive COVID-19 tests. That's the allegation. FFCRA claims regarding not being provided enough sick leave under the law, workplace safety issues, unpaid wages and reimbursements associated with remote work, and some of the new work arrangements that we've got our employees working in, which we're going to talk about in a little more detail. And then whistleblower claims, typically related to allegations that an employee complained that they complained about coronavirus safety issues and then were retaliated against for doing so. Some of the top industries where we are seeing these types of claims include hospitality and retail, which I know is closely aligned with what you guys are doing. So, it's something to definitely be aware of, that we are being hit pretty hard in these industries. What types of claims are we seeing? Well, we are seeing, unfortunately, a lot of representative actions. So those are your class actions or PAGA penalty actions. And those are challenging because they tend to be a lot more expensive to litigate and settle. But because a lot of the issues that are coming out of COVID-19 will apply to your whole workforce, these plaintiffs are able to bring claims on behalf of all employees or large groups of employees within your organization. So they're particularly challenging claims to deal with as an employer. They often involve health and safety violations, wage and hour violations, and then some of the other issues I identified, like discrimination, leaves of absence, and retaliation issues. Those tend to be more your single plaintiff type cases. What types of health and safety issues might give rise to one of these representative actions? Failure to provide a place of employment that is safe and healthy. At least so the allegation goes, right? A failure to provide safety devices, safeguards, failure to implement and maintain an effective written injury prevention program, failure to have an illness prevention program, failure to provide hand washing stations, failure to conduct a hazard assessment to determine if COVID-19 is a hazard in the workplace, which it most likely is, necessitating the use of appropriate protective equipment. So you need to be providing that equipment if you've done a hazard assessment and you think there is a hazard, which I think pretty generally speaking, it's always present to some extent. And we need to be making sure we're providing all of the equipment necessary to our employees to keep them safe and healthy. Failure to establish prevention measures, such as actively encouraging your sick employees to stay home, implementing and keeping up with social distancing protocols. You know, I think we're all experiencing COVID fatigue, and the social distancing kind of wanes at times, and so we need to have management continue to be vigilant about that. And the same with respect to regular disinfecting. And I know, as being that you guys are in the food and beverage industry, I'm sure you're particularly attuned to a lot of these issues, but it's good to remember that your obligation is not just with respect to your consumers, but also your employees, and to protect the company from potential litigation on this front. And also the screening measures are here, you know, temperature checks, pre-shift screening, those are all going to help you defend against potential lawsuits. So what can you do? As I said, stay up to date with compliant local, state, and federal court information. And I just want to say here, you know, I read it without, I'm not going to, without calling anyone out, I don't want to say anything too controversial. I saw a news article, it wasn't anybody in this industry, but a local business that read a news article that said that certain types of businesses were going to be allowed to reopen, and they just assumed, okay, well that sounds like it would include us, so we're just going to reopen for indoor business. And it turns out, actually, you know, if they had read the statute, they would realize they were not a part of that group that was being allowed to open indoor business. And so it's important to go back and read the statute, read the health orders. And I've been doing a lot of that for people, my friends and family as well. So that's something we can always do for you, but you guys can go on the county website and read it for yourself. You should have an illness prevention program with a COVID-19 specific addendum. You should conduct a hazard assessment and have appropriate cleaning measures in place. You also want to keep communicating clearly with your employees. You know, maybe you put a policy into place back in March or April or May, and it hasn't been reiterated since then. Make sure you continue to reiterate and remind your employees, and that management is being really vigilant in that. And some of this here is repetitive, but I can't just reinforce how important I can't reinforce enough how important all of this is. One thing here I'll point out is have clear reporting structures for health and safety concerns, so that you don't end up with one of these whistleblower claims. You know, employees need to know how they can make complaints, and then the person who receives those complaints needs to know how they're going to treat that complaint, and that they're not going to retaliate against anyone for raising their concerns in this area. And then obviously, as we just covered, you do have these notice requirements now that you have to inform the employees if you do have COVID-19 cases in the workplace. Something you may not have thought about quite as much as some of these health and safety concerns are the wage and hour potential claims arising out of the pandemic. And we are seeing tons of these lawsuits get filed. Some of them have to do with changes in the way that we operate our workplace, our workspace, our work sites. Some of them have to do with remote work issues. So in the workplace, I imagine you may have some health screening. You may have some personal protective equipment that you're requiring your employees to wear. If you have employees doing a health screen before they clock in, or if you have them donning a whole pile of special gear before they come and clock in, that is time that is subject to the employer's control, and it needs to be compensated. And in California, we really don't have a de minimis exemption anymore. So if your employees, if say you have 50 employees and they all spend 3 minutes every day doing their screening and donning their protective gear before they clock in, that time starts to add up, and that can be the basis for a lawsuit. So make sure that you're capturing that time on your employee's time card and compensating them accordingly. Let's say you have employees who are purchasing protective gear or getting COVID-19 testing that you're asking them to get outside the workplace, and they're incurring a personal expense for that. That needs to be reimbursed by the company. If that's anything that you've requested as the employer or that benefits you as the employer, even if not specifically mandated, you do need to be reimbursing your employees for any expenses that are related to or in connection with the employee's discharge of their duties. Reporting time pay is another potential issue that you could be experiencing that you may not have had before. So reporting time pay is a rule in California that says when you have employees show up to work and you send them home, so let's say they're scheduled for their shift at 8 a.m., but they show up and they say, my daughter has a cold, and you say, okay, well then you need to go home. Or they show up and they have temperature, they get their temperature checked and they have an elevated temperature and you send them home. You have to pay them for 2 hours of time for reporting to work for that regularly scheduled shift, even if they didn't end up working it. Some additional implications are that you may have a reduced workforce, or you may have reduced work hours because we've all taken a hit in our business, right? So that might impact some areas of your workforce that you hadn't thought through. So misclassification is one potential area of impact. In order for your managers to be properly treated as salaried exempt workers, they need to manage 2 or more full-time employees. Well, have all the employees that they manage been laid off? Are they picking up the slack by doing more of that non-exempt work? Okay, maybe they're the tasting room manager and they used to manage 10 employees and now it's just them and one other person, and they're mostly pouring wine and only managing that one other person. Well, they're no longer exempt under California law, and so you need to turn them into an hourly employee and pay them overtime and give them meal and rest breaks. Do you have commission-based employees who are out there selling and their commissions have dipped so low that now they're not properly treated as exempt employees and they need to be converted to an hourly pay structure? That's possible. You also, maybe you have outside salespeople who go around and sell your wines, to different restaurants and retailers, and maybe they're not spending their time outside the way they used to. Under California law, the outside sales exemption requires that an outside salesperson be working outside at least 50% of their time. Well, if they're spending all of their time in their home office, that's an argument that they're no longer, a plaintiff could argue that they were really no longer an outside salesperson and should have been converted to an hourly employee. And if you have them misclassified and you're paying them on a salary basis, they can come back later and seek all that overtime. They can say they didn't have time for meal and rest breaks and seek penalties and wages, unpaid wages for that as well. Remote work issues that are new that you may not have experience with, because we just sort of transitioned to this work from home model very abruptly, and you may have a lack of clarity on the policies and the expectations. You may have insufficient administrative systems in effect to manage an hourly workforce working from home. These are all things to be aware of. Is there general stress and anxiety among your workforce about this work from home model? Do your employees have limitations based on school closures and childcare closures, requiring your employees to both take care of their children and do their work at the same time? These are really complex issues, and if you have employees that are struggling with some of these things, that could be a time to involve a legal professional to help you make the right call, because as I said earlier, you do have some obligations with respect to the sick leave and the FFCRA to be providing these employees with the time off that they need to care for their family, while at the same time needing your employees to report to work and fulfill the obligations of their job, those can be tricky issues to navigate right now. Some of the other remote work issues that arise relate to personal equipment now that the employees are using to do their job. You know, before they would come into the office and they would use the office computer and printer and phones and internet, and now they're using their personal cell phone. They're using their home internet. They're using their printer. They're buying printer toner and paper, and they're using their electricity, you know, at their home and have increased electricity bills. Well, all of these costs, the employer does have to bear those costs and reimburse the employees. So let's talk about, like, for example, cell phones. You, as the employer, need to evaluate to what extent the employee is using their personal cell phone for personal versus work use, and then you need to reimburse for the work portion. And it can be a reasonable estimate. So if the employee is spending 30% of their cell phone time that month, or generally in a given month on work, then you need to reimburse them for 30% of that cell phone bill. Even though you might think, okay, well, the employee would have been paying 100% of their cell phone bill before they started working remotely, it doesn't matter. The law says that the employer doesn't get to have a windfall of getting, you know, the free use of cell phones and offices and electricity and internet, simply because the employee would have been shouldering that cost themselves before. So you need to make sure you're reimbursing for all of this. Timekeeping and off the clock issues. So, you know, for some of your exempt employees, I'm this way. There's very little boundary between my work life and my personal life, and stuff's coming in on my phone all the time that's work related and personal related. But for your hourly employees, they're not used to that kind of lack of barrier, and it has to be different for those hourly employees, because every minute that they spend doing work for the company needs to be compensated. So you need to put into place policies that make sure that your employees are clocked in and recording on their timesheets any time that they spend dealing with work-related issues. And that means that if at the end of their workday at 5 o'clock, if they handle some emails at 7 p.m. or they have a 10-minute call with you at 6:30, that needs to be recorded on their time clock. And that's going to be a little, you know, challenging of an adjustment, because some people aren't that great at capturing all that time. But as the employer, you need to remind those employees that it's very important that they do so. Okay, I see, let's see, one question. 2 full-time okay, the question is, if you have a manager and the requirement is to manage 2 full-time people, does that mean 2 full-time equivalents? I believe that's correct. I believe it's 2 full-time equivalents, but I will double check that for you because I don't want to give you wrong information. I'm going to make a note here, and we will follow up after. But I do believe that's the case. It's full-time equivalents. If you have an exempt salaried employee, is there any way to do that besides managing 2 people? Well, it depends. It depends what exemption you're claiming, right? So under California law, the baseline presumption is that everyone is hourly. All of us are hourly employees, unless we can qualify for an exemption from the hourly overtime requirements, and then those exemptions are specifically delineated. The exemption tests are somewhat complicated. They're multi-factor tests, and you have to evaluate each exempt employee individually to look at what their actual day-to-day duties are and if there's any exemption that they qualify for. So if you have a managerial employee who is now managing less than 2 people, you may have a problem unless they qualify for some other exemption, like maybe the administrative exemption, or, you know, I don't know which other ones might apply, you know, maybe an outside sales exemption or something like that. But probably assuming that the other ones don't apply, I guess the administrative exemption might apply. but that's probably going to be the only one. And you have to look at the test, which I don't have time to go through today, but I would be happy to talk through that with anyone to see if another exemption might apply. You can also go on the DLSE, Department of Labor Standards Enforcement's website, and they list out each of the exemptions. And so you can look at the factors and sort of try to assess if your employee might fall within one of those other exemptions. Okay, so moving on to independent contractors. Let's see here. Okay, so some of you probably recall that not too long ago we had a California Supreme Court decision called the Dynamex decision, which was a really watershed decision which changed the way that we assess whether or not someone is properly treated as an independent contractor versus an employee. Well, this new assembly bill preserves the test set forth in Dynamex, which is the ABC test for independent contractors, but it substantially expands the available exemptions from that test. And these new exemptions have already gone into effect. So to review, the ABC test set forth in Dynamex said that all workers are treated as employees unless you can prove all of the following: that the employee is free from control and direction of you as the hiring company, that they are performing work outside of the usual course of your business as the hiring entity, and that they customarily engage in an independent trade of the same type of work that they are performing for you. Okay, so they're free of your control. They are doing something that you guys don't do as a business. So what does that mean? Let's say, okay, if you guys make wine, then this person can't be helping you make wine. If they're a plumber and they're fixing the bathroom, then that would be something that you guys don't do. That's not the business you're engaged in. So they could be an independent contractor. And then they have to be customarily engaged in that business. So if someone's doing work for you as a plumber, they have to actually be a plumber in order to be treated as an independent contractor. They can't be one of your wine tasting room employees who is doing plumbing for you, even though they're not trained as a plumber and that's not a business that they regularly have. So that ABC test is still in effect, except we have all these new exemptions that were just built into the law in Assembly Bill 2257. There's a whole bunch of exemptions. I've just included a few here that I thought might be relevant to some of you and your businesses. Business-to-business exemptions, some single engagement business-to-business arrangements, referral agencies, professional services. So if you use an outside marketing person or HR administrator, they might qualify for the exemption. Musicians, so if you have people gigging, at events, which unfortunately we probably don't have a lot of right now, but they could qualify. Artists, videographers, photographers, designers, landscape architects, and competition judges are just some of the few exemptions we now have from this new independent contractor rule. However, with each of these, in order to qualify, there's a long multi-factor test for each one. And so you really need to specifically look at the test and make sure your workers qualify. So, if you say, okay, well, we have this artist doing this work for us, so we can treat them as an independent contractor. Don't just assume that. You really need to look through the factors and make sure they qualify. Not exempted are gig workers. So by that, I mean, these are your Uber drivers and people of that nature. Although we do have a ballot initiative, some of you may have voted already and you may have seen that that's on there. So some of this could still be changing. And I added winemakers and food servers at special events because I know I've heard from you guys before that those are areas of particular concern. I don't see that there are exemptions for these particular types of workers currently in the law. However, where do we go from here? Well, you guys have seen the ballot initiative that Uber and Lyft have, trying to get an exemption for their workers. And all of those exemptions that we already have, those are the results of very concerted lobbying efforts by those particular industries. So, I think if other groups want to lobby for exemptions, such as, this organization could do that. If there was a desire to do that, we may see more exemptions in the law going forward. I don't see any new questions on any of that. So I'm going to move on to CFRA expansion. So CFRA is the California Family Rights Act, and it has been expanded to now require employers with as few as 5 employees to provide 12 weeks of unpaid leave to employees for care for their own serious health condition, that of their family members, or for baby bonding. So this used to only apply to larger employers, but now it applies to you if you have 5 or more employees. And it's unpaid leave that you have to provide, but you have to protect that person's job and give them 12 weeks off to care for that baby or to care for their own health or the health of their family members. This new rule also expands CFRA protection for everybody in that it expands the types of leave that qualify under CFRA to include family members being called to active duty. That's now a reason where you can take CFRA leave. The list of family members that you can take CFRA to take care of has expanded, and the definition of a child has expanded to include the child of a domestic partner. It does eliminate a few things too. There used to be a limitation in CFRA that said if you employ 2 parents, that the family was entitled to 12 weeks total. So let's say you have a new baby on the way and mom and dad both want to take CFRA leave. You used to be able to say, okay, well, mom, between the 2 of you, you can take 12 weeks. But now that limitation has been removed. So each parent is entitled to take the full 12 weeks. There used to be a limitation that allowed employers to refuse to reinstate certain key employees at the end of the 12 weeks. That has been eliminated. They used to do the number count of 5 employees or more. They used to do that number count by saying those employees had to be within 75 miles of one work site. That is no longer the case. If you have 5 employees spread across the entire state of California, then you now qualify and you have to comply with CFRA. CFRA also requires that you have a written policy on CFRA. So if you don't have a written CFRA policy in your handbook, you need to add it. Expanded protection for domestic violence and sexual assault victims. We have already had a law in California that provides these types of domestic violence and sexual assault or stalking victims with certain time off work. This new law just expands that protection to anyone who's a victim of crime or abuse. They have specific rights to take time off work for specified purposes. Pay reporting and board membership. Diversity of board membership. Now this probably doesn't apply to most of you, but I will share it. I'm sharing it with you because if it applies to certain groups of employers, you can sort of expect that it may be expanded to smaller employers and private companies down the road in some manner. So in 2018, we had a law which required publicly traded corporations to have at least 1 female on their board, with that amount of representation increasing by the end of 2021. Well, this new assembly bill expands that law and requires these corporations to have at least 1 board member from an underrepresented community by the end of 2021 as well, with that number of representatives increasing in 2022. Like I said, not necessarily applicable to most of you, but could be indicative of things to come. Pay data reporting. Now this will apply to some of you. If you have more than 100 employees, you, beginning in 2021, have to start submitting pay data information to the California Department of Fair Employment by March 31st, and then every year after that. You have to include information in this pay reporting on the number of employees that you have, and then you have to identify them by race, ethnicity, and gender, and job category. You're going to have to provide W-2 earnings for each of these folks and information regarding their hours worked. Why do we have to start reporting this information? Well, the Department of Fair Employment and Housing wants to have increased visibility into your workforce so that they can investigate discriminatory pay practices. So I think what you can expect from this is that we might see the DFEH pursuing discrimination claims against organizations where they don't feel that these numbers or where they feel that this information is indicating some kind of discriminatory practice. Now, whether or not, some of the criticism of this rule is that these numbers on their face aren't going to necessarily accurately convey whether or not there's a discriminatory issue within the workplace, but that is the intent of the DFEH, to start investigating these potential discriminatory pay practices with this information. Okay, we have a few minutes left to discuss other new legislation. Assembly Bill 1281 extends an exemption for employers. So this is a little bit of good news for employees, that as you know, given that you guys are in business with providing products to consumers, you may already be familiar with the California Consumer Privacy Act, but you have obligations not only with respect to your consumers, but with respect to your employees under this act. Now, the exemption for employees or employers as employers has been extended by this law to give you 1 more year to comply with some of the CCPA requirements. However, that exemption does not apply to the notice provision, which requires you to provide notice to employees of personal information that is being collected from your employees and the purposes for which it is going to be used. So that you do still have to comply with. So, that's something that you want to make sure you're doing. Something that we do for clients is, we assess the types of information that you're collecting from them during the application or onboarding process, and then make sure you have an appropriate notice that you're providing them that is compliant with this CCPA. Corporate statement of information. This doesn't go into effect until January 2022 or whenever the Secretary of State implements this California Business Connect program that they're supposed to be launching, whichever's earlier. But as I'm sure you all know, existing law requires you guys to every corporate entity to file a statement of information with the Secretary of State. Well, when you file that statement of information, you now have to provide information about whether or not any of your officers or directors have outstanding final judgments issued by the DLSE or the court for a violation of the labor code. So if the labor commissioner has ever issued a judgment against any of your directors or officers saying that wages were owed, then that now has to be disclosed on your statement of information. In addition, it establishes that any successor to a judgment debtor is liable for any wages owed to the predecessor's workforce. So let's say you guys acquire another company and that company owes wages to their workforce. You're taking on that liability by acquiring that company. So before you acquire a company or another business, it's definitely a good idea to inquire into any exposure in that area. Extension of time to file labor complaints. This is just a new law that says that employers have longer to file their claims with the labor commissioner. I don't know if any of you have had experience with the labor commissioner, but employees can, short of bringing a lawsuit, they can pursue their wage claims and certain discrimination claims or wrongful discharge claims. They can pursue them with the labor commissioner. And now they have, they used to only have 6 months to bring those claims. They now have a full year. Real quickly, I'm just going to go through this stuff right here. No rehire provisions, something that California law banned last year was the inclusion of a no rehire provision in your settlement agreements, unless it was a case where you had previously determined that the employee had engaged in sexual harassment. You can have a term in that settlement agreement. If they engaged in sexual harassment, you can have a term in the settlement agreement that you won't rehire them. And this new law expands the exemption to include, it doesn't have to just be instances of sexual harassment. It can be any instances of criminal conduct. Now, I want to reiterate that in order for this exception to apply, you have to have documented your determination prior to the claim being filed, that you determined that there was some criminal conduct or sexual harassment. Now, let me just be clear. There's no rule that you have to rehire or retain an unfit employee. This rule just limits your ability to put a no rehire term in your settlement agreement. Now, the last piece of substantive litigation I want to touch on real briefly is this HR mandatory reporter rule, which says that HR employees of a business with 5 or more employees, if you employ any minors, you are now a mandated reporter. Mandated reporter being someone who is required by law to make reports of suspected child abuse to local law enforcement. So your HR people become mandated reporters, as well as any employee who supervises and comes in direct contact with your minor employees. They are also a mandated reporter. And as the employer, you need to provide training for those mandated reporters on how to identify and report child abuse and neglect. You can meet that training requirement by completing the online training course offered through the State Department of Social Services. They have an Office of Child Abuse Prevention, and they have an online training component there. Okay, if any of this has been helpful for you or completely overwhelming, then maybe you would rather get this information in bite-sized chunks, and you can follow us on Twitter and follow our blog, and we post these new laws and any other significant developments in the law. We post them regularly to our Twitter, our Twitter handle and our blog, and so you can subscribe to them at the information provided here on the screen. And if anybody else has questions right now, feel free to type them into the Q&A or the chat. And you can also reach out to me and email me afterwards. I'll just say now, I'm sorry that I don't have more good news to share. I never have good news to share during these presentations. And certainly this year has brought about a lot of legislation and litigation that we never thought we would have seen. If you'd asked me this time last year, all these COVID-related laws we never expected to see. But here we are, and we're hoping for good things in 2021. Seeing no questions, I will say goodbye. But please don't hesitate to reach out to me if you have more questions. And I think Jesslyn is going to make this presentation available for replay if you have other folks who didn't get a chance to tune in today. Thank you for your time. And I'm going to say goodbye.